Welcome. My name is Mark Biernath, and I'm an estate planning attorney. This is part 4 of our series on special needs planning. Earlier, we've looked at things as to why special needs planning is important, what should go into a special needs trust, and some common mistakes that parents make when planning for their children with special needs. In this section, we're going to look at how to create a special needs plan. And to do that, we're going to start by looking at wills and trusts.
So we've talked about what a special needs trust can do. Let's talk about how it should be created. And we're going to kind of move through this a little quicker. In order to understand how to create a special needs trust, we need to understand a little bit about wills and something called an inter vivos trust. Inter vivos is just stupid lawyer language, which means it's created during life. There's certain words that we try to get rid of, but there's just no good little convenient word to substitute. So inter vivos is one of them. Per stirpes is another. And people look at me like, what's per stirpes? That's a way of passing assets down to your children. But a will is just simply a written document signed in a manner prescribed by law, which disposes of your property upon death. Pretty straightforward. Georgia has some pretty formal requirements for a will. Further west you get, the less formal the requirements are. East Coast, they stay pretty formal. There's a very simple and easy explanation for that. As this country was developing, guess where all the lawyers worked? Along the East Coast. So of course the requirements were more formal because you needed to use an attorney. Further west you got, fewer attorneys. They had to allow people to handwrite their own will. So, but do you think we're going to change that? No. We got it. As my property law professor said very clearly, it's good to be part of the profession that makes the rules. So, a will nominates who should be responsible for wrapping up your affairs, commonly referred to as an executor. The new term is personal representative. Nominates guardian for your minor children, and I need to update this slide because now with the new guardianship code, you can actually nominate guardians for your adult children, which this afternoon's discussion, that might become very important. Can determine how, when, and where, and all the details about how your heirs are going to receive their property, and also make provisions for paying taxes, if any. A will must be probated in order to become effective. Relying solely on a will, you guarantee a probate. Because if the probate doesn't happen, the will never has any force or effect. A will may only be probated upon death of the will maker. So you're not going to have anything to do with the probate of your will, other than your death certificate will be attached to it. Only upon sufficient proof that it is the will. So the probate process is a process of saying this is the will, this is how we know it's the will, and then the court empowering somebody to do what the will says. It is a court-determined process. The executor has to report back to the court, has to keep the court aware of what's going on, and then finally needs to tell the court, okay, we're finished, we're done. Court may oversee administration of the entire process. And one thing we're going to get to when we talk about whether to create this will, this trust, the special needs trust through a will or presently created, that's going to be very important. Wills are part of a public process. Does not provide for the incapacity of the will maker. If you become incapacitated, your will doesn't happen. Remember, you have to pass away before that will becomes effective. Trust, on the other hand, is a private agreement between a grantor or trustee for the benefit of the beneficiary. In Georgia, that person can all be the same. So what this means is you can create a trust for yourself where you're the trustee and you're the beneficiary. Then when you're no longer able to do it, someone else that you've named steps in as trustee. You're still the beneficiary. So that's a very convenient, helpful tool. It does not protect from your creditors, though. So I see some eyes going, ooh, that's great. Trust can be established for yourself. If it's established for someone else, it can protect assets from creditors. Medicaid is a creditor. Some want to call it a predator, but technically it's a creditor. You can nominate successor trustees in the event that the trustee becomes incapacitated. You know, you can name a series of people. You can name hundreds of people. I wouldn't do that, but you can. And the key thing with the trustee is they're not they do not report to the court. There's no court oversight of the administration. So this trust, the special needs trust that we've been talking about, can be established either by will or during life, this inter vivos trust. If it's established by will, there's a time-consuming delay built into the probate process. Has anyone had the experience and pleasure of having to do a probate? It doesn't happen quickly, does it? Usually there's about 3 to 4 weeks before the will ever gets to court. Then the calendar starts running once it's filed. If everybody signs off on the back page like they should, it can go faster, but usually at least one person either can't be found or we need to do the publication. That's 6 weeks right there. Then there's a 3-month window for creditors to make their claim. So right there, we're just talking 6 months without any complications. Add to that a special needs child, you have to have a guardian ad litem appointed to represent that person. Number one, that costs more. Number two, that takes more time. Usually I tell people a normal probate takes about 12 months in Georgia. Sometimes it can be done a little less, usually about 12 months. Complicated one can go 2-3 years. Where do you fit into that? Probably somewhere between 12 months and 2 years. There's the additional expense of probate. You also have the question, well, what if the will's never probated? If the will's never probated, the trust never gets created. What if laws change? And here's the biggie. The court may choose to retain jurisdiction over the special needs trust for the entire lifetime of your child. More and more probate judges are doing that. If this trust is established during life, it's in effect immediately. You can name your trustees, your successor trustees, and you can kind of get them knowing how it works and how things happen. And here's one of the key things. That trust, when it's created now, can be the beneficiary to life insurance. Life insurance pays its death benefit within weeks of receiving the claim form. So what that means is you get the death certificate, file the claim form, within, I've heard as little as 5 days, the money is in the trust ready to work for your child. The will can take 2 years, who cares? We've got money to meet the needs of our special needs child. And whoever's going to be caring for your child has the money they need. If there were no other reason, that reason alone is a good reason to create the special needs trust during life. Other people can leave assets to that same trust. Grandparents don't have to create a different trust for the child. They can all use the same trust. And if laws change, the trust can be amended so long as we're still in that amendable period.
While there are times where it may be appropriate to create a special needs trust in a will, my general preference is to create it as a presently created inter vivos special needs trust. This way, you take full advantage of all the benefits of having the trust already created and avoid many of the questions and uncertainties that the future may hold. In this section, we looked at how to create the special needs trust. In the next section, we're going to look a little closer at what to include in a special needs trust and what it is you need to do in order to protect your child with special needs. So please join us for part 5.